I mean, I think it would be a shared responsibility on the part of appellant and the court.
Why is it the court's your people dropped the ball?
RIOS versus St. Barnabas. You may proceed.
Good afternoon, Your Honors.
Afternoon.
This is a medical malpractice case involving allegations of failure to timely diagnose an ectopic pregnancy on the part of the respondents. The appellant presented to the St. Barnabas Hospital Emergency Department on July 9, 2000.
Yes, but she didn't follow instructions, did she?
No, actually, she did follow her.
No, she didn't. She was supposed to go to the clinic within 48 hours.
And she did that.
And she was supposed to have blood work done.
And she was told that the clinic was closed. When she went to the follow-up appointment at the clinic on July 11, 2014. She saw the midwife there. She was told she was told that the clinic was closing. They couldn't do blood work that day because the clinic was closing at 4 p.m. She was told to return in a week.
And when she was leaving the building, she saw that the lab was open.
And she relied on the midwife.
And she didn't open the door to see. She is told that she has a potentially life-threatening situation going on, right? That she needs this blood work so that they could see and determine how bad her situation was becoming. And instead of going to the door where there are people that she can see through the glass, she leaves.
She followed the instruction that was given to her by the midwife.
Let me ask you this question. She was also instructed if you don't go to the lab, you can also go to the emergency department, correct?
She wasn't instructed that by the midwife.
Well, let's assume that she was also instructed to go to the emergency department, but did not. What was the reason for not going to the emergency department across the street? Because I thought there were two instructions.
She was told that there's documentation indicating that she was instructed at the emergency department visit on July 9, 2014, that if she could not go to the clinic on July 11, 2014, she should come back to the emergency department. But she in fact did go to the GYN clinic on July 11, 2014. So that instruction from 2 days ago at the emergency department no longer applied, and she was going off the instructions given to her by the midwife on July 11.
Let's stick with the initial time, and I'm talking about the 9th, because from my recollection, both the plaintiff and her husband signed off on the fact that they received instructions about how life-threatening this was, and they needed to follow up. Is that accurate?
I don't think her husband was there.
Yes, he was.
Yeah.
Okay, very well.
That they verbalized their understanding of the need of a follow-up in 48 hours, because it was stressed that it was life-threatening and the importance of going in 48 hours.
And she did that.
Counsel, this was a verdict after trial.
Yes, Your Honor.
At which your client testified?
Yes.
And at which the midwife testified?
Yes.
And the issue that we are discussing right now is whether or not the lab was open and whether or not she was instructed to go to the lab by the midwife, because that particular instruction did not appear in the records. Is that it? Am I correct?
Which instruction?
The one that the midwife gave her, go immediately to the lab and have your blood drawn, because we need to know. We need to know whether or not certain numbers have increased to know if you're having an ectopic pregnancy.
So the medical documentation of the July 11, 2014 GYN clinic visit does not reflect that she was instructed to go to the lab.
Exactly.
Blood drawn that day.
But the midwife says that she did instruct Ms. Rios to go to the lab that very day,
That's what she said.
right? And she had finished, although the lab closed, according to the midwife, at 5, the examination of Ms. Rios had ended way before 5, somewhere between 4:07 or 4:20,
Yes, that's according to the midwife,
according to the midwife.
5, but
So-
according to the plaintiff, she was told it closed at 4.
Right, so now we have a credibility issue that has been left for the jury to decide.
Yes, and that credibility issue is affected by the point, the evaluation of that credibility issue is very significantly, substantially affected by the issues I raised in my papers.
I
Well,
understand.
I'm sorry, may I?
Yes.
A lot of this is focused on what is unusual, to send a trial subpoena, when we know we're dealing with a discovery issue and that there was a full and fair opportunity to really question the midwife during her deposition. The discussion of times really wasn't explored. You claim it was serviced during the trial, correct?
Yes, it was served during the
Okay,
trial.
and with all that Sturm and Drang, at the end of the day, by the way, I went through this record, and correct me, was there a charge conference?
I believe there was a charge.
And did you put in a missing witness charge as your request? Because I couldn't find it in the record.
So I wasn't at the trial personally. I'm informed that there was a missing document charge request made, but it's not
In the record.
In the record.
And not only isn't it in the record, there was no objection made at the close of the case, when the judge gave the instructions, say, Your Honor, I object to not giving a missing witness charge here. I'm sorry, missing document charge with respect to the very document you were seeking, because you were really seeking to get the lab times, correct?
That's correct. That's correct. There was no objection to the charge as given at the time it was given.
Okay.
Thank you.
Thank you.
Okay.
May it please the court, my name is Nicholas Hersler. I represent defendant Chaperone in this case. Your Honors, this was a jury trial. The jury had extensive evidence before it that my client did not.
But before the trial, there were some depositions, no? I mean, there always are.
There were depositions. The depositions, it was brought up where the plaintiff testified that she was told that the lab was closed, and then at the defendant's deposition, it was brought up that she said that it was open.
Right, and this was never pursued any further during the discovery stage of the case.
Precisely. It would have been after the deposition, plaintiff should have served a post-deposition demand for a copy of the lab schedule.
And I think the judge mentioned that at some point also.
That was mentioned, absolutely. The judge noted that that issue had not been explored and that it was untimely raised during the trial, that the plaintiff was attempting to get discovery for the first time during the
Although, so then there were some subpoenas served during the trial, is that correct? For the records, to see if there were any records that related to the opening hours of the lab at the relevant time, right?
Not exactly. The court gave permission for plaintiff to serve a subpoena on St. Barnabas. However, the plaintiff did not serve a subpoena. Instead, they informally emailed a request to St. Barnabas for the prescription and the lab schedule.
And there was never any response, and the trial ended, and sort of nothing happened about that, right?
Correct. There was not enough time for the hospital to search for documents. It was 9 years after the event. The plaintiff had waived the issue during discovery. The hospital could have searched for documents during the course of discovery. And so the issue having been waived, and then the plaintiff having waived the request for missing document charge as well, at that point, plaintiff has no basis to challenge the verdict based on evidentiary errors. And because the verdict is more than supported by extensive evidence in the record that my client did not depart from the standard of care, the judgment should be affirmed. Moreover, the jury did not even reach the issue of proximate cause. So any argument by plaintiff as to an error would be harmless.
He answered no on the first question?
Correct.
Is that correct?
Correct. I think the court understands my argument, and I'll rest on my papers unless the court has questions.
Do you have a question?
No, okay.
Thank you.
Thank you.
Good afternoon.
Good afternoon.
May it please the court. My name is Samantha Quinn. I represent St. Barnabas Hospital. I will try to be brief because many of the points have already been raised by my co-counsel.
Well, counsel, one of the issues was raised by your friend was the fact that there was cross-examination of the plaintiff about her cocaine and marijuana use on July 10th, the day before, or around that time, and they objected to it as being prejudicial and irrelevant. But didn't the plaintiff submit all the hospital records, which includes that notation?
Yes, in fact, it was on the 17th when a pre-anesthetic note was entered into the hospital record, and Ms. Rios admitted that she had done coke and pot 7 days prior, which would have been the 10th. So after the 9th, prior to the return visit on the 11th. So that was it was part of the hospital record.
Which was not objected to?
No.
The entire record?
Regarding the issue of the schedule, first of all, it was never established that there was actually a written schedule for the lab. This request came in mid-trial, and it was 9.5 years after the events in question. The plaintiff was deposed in 2016, and at that point, she claimed that the lab closed that she was told the lab closed at 4. Nurse midwife Chaperon was deposed 2 years later. It was a 39-page transcript. She was never asked any of these questions. And Judge Jerez appropriately commented in the record, this is at 5:01, okay, I do believe that these are questions that should have been asked at the deposition. So you know, these are questions that if you had been asked, you would have elicited the information. It seems like there was a very short deposition of the main defendant in this case, and that questions that should have been asked perhaps were not. Additionally, plaintiff's counsel at trial effectively waived this issue. In the record at 490, Mr. Capel states, the only issue we are trying to protect against is somehow that during the examination, a document comes before us that we haven't seen before that contradicts the case.
Would the lab hours be something that would be contained in the medical records?
I don't believe so. And again, Judge Jerez asked that the trial counsel for St. Barnabas make a search, which she tried to do, but it was so late that, she did not get a response to that or the issue of the prescription. Additionally, the plaintiff's own expert admitted that the lab was open at record at page 451. Question. So would you agree with me, doctor, that Ms. Rios went down to the lab as directed by Nurse Chaperon, that in fact the lab was open? Answer, it appears so. Question, and doctor, she didn't go inside, correct? Answer, I don't believe that she did.
So the jury heard this testimony, right?
Yes, they did.
So even if we didn't have the records, or you didn't have the records, which obviously you didn't have the records, they heard this back and forth and could make their determination based on that.
They did, and they decided that they would credit the testimony of the defense witness as opposed to the plaintiff, and that's within their province. That there's absolutely nothing to indicate that this verdict was against the weight of the credible evidence and nothing to indicate that it should be set aside.
Thank you.
Just briefly to respond to a few points raised by respondents. Based on midwife Chaperon's own brief, the court actually ruled in plaintiff's or appellant's favor with regard to the issue of the subpoena for the lab hours. But then inexplicably, the court allowed the case to go to the jury without those lab hours.
Did the plaintiff make any type of objection during the charge conference or whatever? Judge, wait, we have to, follow up on this issue. I mean, shouldn't that have been your responsibility? Maybe not you, but whoever is representing the plaintiff at the trial?
I mean, I think it would be a shared responsibility on the part of appellant and the court.
Why is it the court's your people dropped the ball? You had all the information you needed from the EBT to make the discovery request that you now claim is the end-all, be-all of your case.
Actually,
And so you wait until trial, all of a sudden a light bulb goes off, and that becomes somebody else's problem. That's not how trials work.
Actually, we didn't have the information. The midwife never mentioned that it was.
Counsel, are you saying that what was discussed by your adversaries regarding the depositions and the time, the issue of what time the lab was open or not open, you didn't know that?
We didn't know the midwife's position as to what time the lab.
But you knew what your client's position was. How about you verify that? It would have been that simple. But we've got your brief. Thank you so much.
Okay, thank you, Your Honor.